The National Association for Gun Rights, NAGR, announced today that its legal team has filed an appeal to the United States Supreme Court challenging Connecticut's ban on so-called assault weapons in standard capacity magazines. The appeal follows a ruling for the U.S. Court of Appeals for the Second Circuit, which upheld the Connecticut ban and in doing so openly defined existing Supreme Court precedents established in District of Columbia v. Heller 2008 and New York State's Rifle and Pistol Association v. Bruen 2022. The Second Circuit's decision is one of the most brazen acts of defiance toward Supreme Court precedents that we've seen yet, said Dudley Brown, president of the National Association for Gun Rights. If left standing, it would effectively render Heller and Bruen meaningless and give rogue judges the power to gut the Second Amendment. NAGR's case, National Association for Gun Rights versus Lamont, is widely considered a key test for whether the Supreme Court will finally address the constitutionality of bans on AR-15s and similar firearms. Justice Brett Kavanaugh recently remarked that the court should and likely will address the AR-15 issue soon in the next term or two. In its ruling, the Second Circuit conceded that AR-15 style rifles are in common use, but nevertheless argued that governments may still ban them. That position directly contradicts the court's holding in Bruen, where the common use standard was highlighted as central to evaluating restrictions on arms. This case isn't just about Connecticut, Brown added. The Second Circuit effectively invited other jurisdictions to ignore Supreme Court precedent, daring the justices to step in. It's time for the court to slam the door on lower court defiance and reaffirm that the Second Amendment means what it says. If the Supreme Court grants review, the case could become the defining battle over the legality of so-called assault weapons bans nationwide, with sweeping consequences for the future of gun rights in America. So what exactly does all this mean? It means the National Association for Gun Rights has filed an appeal to the Supreme Court and has stated, hey, the assault weapons ban that is in place in Connecticut is unconstitutional and it needs to be reviewed again. I can definitely commend these people for trying to help us over here in Connecticut. I think it's really great that people haven't necessarily given up on us, but at this point, I am not too hopeful for any change in Connecticut. I think that at this point, yes, we do still need to continue to fight, but I'm not really exactly sure where this is going to go. I do know it's going to take a little bit of time, as, when it comes to dealing with things in the court system, it does take a very long time for anything to come about of anything, whatever decisions are made. And what I can say is I do know a few months ago it did come out that, the courts ruled in Connecticut that firearms like AR-15s with detachable magazines or anything else that's defined as an assault weapon in Connecticut are considered to be unusually dangerous firearms. And I think that is absolutely a ridiculous statement, but that's just what they've ruled. And being that they just ruled on this again, like I said, just a couple of months ago, that information came out. I'm not really exactly too hopeful on where this appeal can go. I do think, anytime they, they say anything that's not what we exactly want to hear in Connecticut, I think, of course, dealing with these people, you should appeal it every single time. But I don't know. But let me know what you guys think about this. Leave a comment down below and carry on.